Hello, everyone. How are you doing today? Thank you guys so much for joining us. And thanks, Sabrina, for that wonderful, wonderful meditation experience. Can everyone hear me okay? Perfect. Well, I'm excited to be able to kick off this, one of the first topics that we're discussing today. And as Natalie mentioned, I am Walker's Legacy Director for Philadelphia. I'm very excited to support this amazing organization. I will be moderating the Unemployment 101 session, What to Do If You Get Laid Off, again with Miss Jessica Childress. Good morning, Jessica. How are you? Make sure you take yourself off mute. I forgot to do that too.
Perfect. Can you hear me?
I can. Can you hear me okay?
Hear you well. How are you doing this morning?
I'm doing super well. All right, so we are ready to rock and roll. So I'm going to go over and share with everyone an amazing bio, and then we're going to jump right into some of those topics. But keep in mind, if you do have any questions, we will try to allocate time where we can to get to those. So Jessica N. Childress Esquire is the founder and managing attorney of the Childress Firm PLLC, an employment law firm based in Washington, D.C. She holds a Bachelor of Arts in Government and African American Studies from the University of Virginia and a Juris Doctor from the University of Virginia School of Law. Jessica graduated Phi Beta Kappa with high distinction from the University of Virginia in 2007. After law school, she served as a federal judicial law clerk for the Honorable Alexander Williams Jr. in the United States District Court for the District of Maryland. Ms. Childress has served as an associate at 2 global law firms and as an attorney for the United States Department of Justice. Jessica represents clients in all aspects of employment law. She has litigated retaliation, discrimination, sexual assault, non-competition, trade secret, unfair labor practice, and whistleblower cases before various tribunals. She serves clients in general business transactions with employees and independent contractors. Ms. Childress drafts agreements such as employment agreements, consulting agreements, termination agreements, and confidentiality agreements. While in law school, Jessica was an editorial board member for the Virginia Journal of Social Policy and the Law. She was also an executive board member of the Student Bar Association. Additionally, while in law school, she served as a legal intern in the United States Attorney's Office for the Eastern District of Virginia. She is an alumnus of the National Trial Advocacy College. Welcome, Jessica. How are you today?
Doing well.
That is a beautiful, beautiful bio. I'm so inspired, and thank you for all the work you've done. Before we get started, though, how do you feel when you hear such glorious things about yourself?
You know, it's weird because it seems like so much time has passed and those things. I love practicing law and I do the work that I love every day. So it goes by quickly, but then when you think about, law school and the amount of experiences that you've had and the ways that those have shaped you and the person that you've become today and the knowledge that you have today, it's really,
Right.
I'm very, very humbled.
Wow. Well, we know in these uncertain times, there are some certainties that have been presented to us. And so we thank you for all the work that you do, especially in this particular element of law, because we know that there are many challenges that people face, even outside of COVID-19, that they face when it comes to their employers. So I do want to start off with one question, and this is just to kind of level set the conversation. And for those who may not be aware, because this may be the first time anyone has experienced unemployment. So the first question that I have for you is, can you just tell us what are some of the basics of unemployment?
Sure. So first, I'd like to start off by saying we are absolutely in uncertain, unprecedented times. There's never been a time like this in my lifetime, and I'm sure yours, Alexia, lifetime. We've seen the drastic effects that we're facing on the economy, where employment laws are changing every month, where businesses shutting down every single day and livelihoods are affected on a mass level. And so right now, I'd like to just say that there's nothing shameful about applying for unemployment. I think there's a lot of, there are negative stereotypes associated with unemployment. We all get these images of unemployment lines, but unemployment, it's your right to apply for unemployment. An employer cannot prohibit you or retaliate against you for filing for unemployment. An employer can test your application for unemployment. But we'll get to later in the discussion some of the requirements that have been relaxed that allow you to more easily apply for unemployment due to the circumstances surrounding COVID. But I'd just like to start off by saying unemployment is your right. If you meet eligibility requirements for receiving unemployment, it is your absolute right as an employee to file for it. And the unemployment office will determine, once you do file your application, they'll determine your eligibility once you get that application in.
Okay. Thank you. Thank you so much for that, because I do think that oftentimes, I think myself included in the past, if you've experienced some sort of separation from the company, and especially through quote unquote no fault of your own, it can be difficult to select and utilize the benefits that are there for unemployment, but that's what they are benefits. So thank you for relieving persons too who may be listening or sharing beyond, that there's nothing wrong. So that's what Jessica shared with us. Please do not feel shameful. It is your right. And the contestant side of it, if that should occur, is going to come between the unemployment division. So you don't have to worry about that with the attorney. Great. So when it comes to unemployment, and you mentioned this a little, and we're going to get into that conversation now. When you apply, how do you go about applying for unemployment for those who may have never had to do that before, or it may have been a really long time?
Sure. So unemployment is highly regulated by the state. We're now seeing federal intervention because of COVID, and the federal intervention allows it gives states more money to provide unemployment benefits. But still, unemployment, it's regulated by your state's Department of Labor. There's an unemployment division. It's usually called the Unemployment Insurance Division. So employers premium into the unemployment insurance fund, and that's the fund that the unemployment office is paying you with when you get an unemployment benefit of a check for unemployment. So if you are applying for unemployment, traditionally you could go into an office. Now with COVID, their acceptance of applications online, that's now becoming the norm, or even a telephone call. You can place a telephone call to file your unemployment application. So offices are typically closed in this period, but check out your state's website, and that's going to give you all the information that you're going to need, because you are going to have documents showing that you've lost your job or that your hours have been reduced, and the reasons documenting why you're applying for unemployment. You will have to have all of that information, but you can apply. You don't have to go into an office. You can typically apply online or apply via telephone. So the process is fairly streamlined once you get it started.
Awesome. Awesome. Thank you for that. Now, something you mentioned just made me kind of think when you're talking about applying for unemployment. So what about the persons, and maybe this is a misconception, I'm not sure, but this is a good time to clear it up. Should you resign from your job to collect unemployment? Because it almost seems like there's been this confirmation that everyone can get unemployment. So should you resign from your job during this time?
That's a great question, Alexia, and that's very much a misconception. It's very difficult to get unemployment if you resign. So if you're involuntarily discharged from your job, that means you're terminated for no fault of your own, you are laid off. That's when you are going to be eligible for unemployment. It's not to say that you can't get unemployment if you resign, but you're going to have to show that the circumstances were so terrible that it's what's called a constructive discharge in the law, that you were constructively discharged. You just could not tolerate your place of employment. And I know many people listening are probably like, oh, yeah, me. But that standard is very, very high. It has to be a severely pervasive, there has to be severely pervasive circumstances, severe hostility that you're enduring. And again, you might think that's you, but before you put in your 2 weeks notice or your resignation notice the day of, please do because the unemployment office does not look kindly upon voluntary resignations.
Okay, that's important. So another thing that came up for me is several states. And so again, what Jessica shared with us, for everyone who's tuning in, thank you so much for joining us. We are talking about Unemployment 101. But one of the things that came up for me is that different states do have different expectations around the ability to leave involuntary, and I forget what it's escaping me, the name of each state.
Unemployment, the division of unemployment.
Yes, so the division of unemployment. So when it comes to each state, right, each state does have different expectations. And so they could, in fact, separate or in that agreement, that employment relationship without just cause. So how does one in this particular time distinguish the difference between maybe this is a separation because of COVID, or this person is taking it personal? So I know there's oftentimes where states can make that decision, or persons can make that decision because of the type of state requirements that are set in place.
Sure. So just to make sure, I want to make sure I understand your question, Alexia, but I think that if someone leaves the job, so let's say that their hours are reduced because of COVID. Now, federal legislation and some states now are coming down. So again, starting off at the baseline, if you've just joined us, unemployment is highly regulated at the state level. States typically set a standard for when you are allowed to receive unemployment. The federal government has come in through the CARES Act and said there are certain circumstances, states, that we're now allowing and asking you to consider if someone has to leave the job because of COVID. If you're reducing hours because of COVID, or if someone is diagnosed or caring for a family member because of COVID, states, we want you to allow those individuals to receive unemployment compensation. Okay? And so now, if someone leaves the job because of, you're going to have documentation to show I left my job because of COVID. It's not, and so you'll have to get a doctor's note. There are some circumstances in which you can self-certify, but if you are leaving the job, I mean, if you can't go to work because you're caring for a family member, you are going to have to show to the unemployment that that's the reason why you can't come to work. And if your employer terminates you for that reason, that's another conversation, but the employer can contest your reason for unemployment. So as filing, in your filing, you will have to show the reason why you think you're entitled to that unemployment. Your employer, the real reason, and we're contesting it, but they can't stop you from filing your application.
Got it. Thank you so much for that. And for everyone, Jessica mentioned the CARES Act, and that stands for the Coronavirus Aid, Relief, and Economic Security Act. So if you hear it referred to as the CARES Act, that is the legislation that has been put in place to help us understand the unemployment and the options that have now been made available. So if we could just shift gears to look at the side of the employer now. So what should employers understand about the unemployment compensation and claims program specifically during this time?
Again, they definitely should understand that they cannot prohibit an employee from filing a claim for unemployment insurance. That's interference. That's absolutely unlawful, not just in this circumstance because of COVID or the CARES Act, but in general, an employer cannot prohibit an employee from applying for unemployment. Employers should also understand that their rating in the unemployment compensation system, the rating that determines their premium, is typically not going to be affected, depending on the state. So these claims that are paid out, it should not affect your unemployment compensation insurance rating in your state system. So that's a state-by-state determination, but states are typically on the trend or moving towards the trend that they're not allowing these claims to affect employers' rating. Okay, and also employers should try their best just to be as generous as possible in determining leave. But we can talk a little bit more about leave allocations and the FFCRA, the First Family Coronavirus Response Act, because that's another type of paid leave that now the federal mandating for employers who have 500 or less employees, allowing 2 weeks leave for employees who are caring for a family member or caring for themselves because of COVID. So these are some alternatives to termination. They allow employees to continue to be financially viable during this time.
Now that's interesting. So the name of the Leave Act, again, you said it's
First is Coronavirus Response Act, the FFCRA.
FFCRA. Okay, that's really important to note, because again, for employers who, like you said, maybe they want to offer the leave, they want to be generous, they want to operate in some sort of compassion, but want that option to be able for the employee to be able to return to work. So again, that brings up another question, just on the along the lines of the employer, right, and the employee relationship. So if someone should, let's say, be laid off as a result of it, are we seeing a lot, or could there potentially be some challenges on the side of the employer with bringing people back once we have been able to regain our new normal, which is post-coronavirus COVID-19 experience? So should we expect to see there are some employers who won't bring as many people back, or how does that work for them? What should they keep in mind?
So once you have severed that relationship, if you've actually instituted a termination, that relationship is over. It's like a divorce. Legally, you're separated. You're no longer together. You can, of course, recruit. You can ask that employee that you have terminated, if that was a great employee and you want them to come back, you can ask them, but they're under no contract unless you have instituted some employment agreement. And most of us are at-will employees with no employment agreement. So you really severed that relationship. So you should make careful decisions about your workforce when you are making termination decisions. And I understand from the employer's perspective that this is a very difficult time, because businesses are not, the cash flow is different.
Yeah.
They're not bringing in as much cash. Very hard decisions have to be made. But when you do make that termination decision, not only is that a very risky time in the employment relationship, because you do bring up a host of considerations that need to be made. You need to think about whether the decision was lawful under the EEO, Equal Employment Opportunity laws. So you cannot discriminate, you cannot terminate or make an employment decision based on race, sex, national origin, in many states, sexual orientation, pregnancy status. All of those laws are certainly still in effect. And so you have to do this careful consideration. You also need to make sure that you're not making a decision based on disability. And COVID right now is not considered a disability under the Equal Employment Opportunity laws, but the manifestations of COVID, respiratory failure, could actually, pneumonia could actually be a disability. So you have to walk a very fine line and make sure, because we are seeing claims now of people saying, I'm being terminated because my employer thought I was sick. And so as an employer, you need to make sure that your decisions, your termination decisions, are on legal grounds, because it's one thing to pay out into an unemployment insurance fund, another thing to get sued for discrimination. And those claims, we are really in a new terrain, and I foresee a lot of those claims coming down the pipe.
You know, thank you for bringing that up, because that was actually going to be one of the questions that I asked, is around the unlawful terminations, if you will. And so how does someone know, or I'm sure it feels like an assumption, and as far as, was I terminated because of COVID, because I was sick, but I really wasn't? And where does that fall as it relates to the Equal Opportunity Employment Division? So if someone, they're questioning, and again, this is not to encourage or say that every employer is doing this, but if you're not sure where you fell within that, how should someone, an employee specifically, what steps should they take to just at least identify if that's where they are? Should they start with the EOC, or should they maybe seek legal counsel first? What would be your suggestion?
It's difficult. I mean, in the race context, I mean, employers typically aren't so stupid to say, I'm terminating you because you're, XYZ race. In the COVID context, it's so new. I think employers are things that are, from a legal perspective, are just stupid. sorry, but like
No, that's legal terms.
this is the very, they're saying, I think that you're sick. And so that right now is not a claim, but it could be down the road. And it's really going to, we haven't seen the courts weigh in on this. And so the employer does have a duty to protect their workforce, but they can't terminate. If they think that an employee is sick, they should tell the employee to go home. So in terms of, and you can do that within the realms of the law right now. The EEO has said if you think the employee is sick, you can ask them to leave, you can take their temperature, you can say, you know, you can ask, are you exhibiting signs of COVID? But then if you say exhibiting signs, we're going to terminate you, you are getting into some very risky territory. And because this is such a novel circumstance and this is a very serious illness, it is, some questions do have to be asked, and I can't say that they are terrible questions, but there is a way to ask them in a sensitive way. So if you say you are sick, you're fired, you're really getting into a very, very risky, you're on risky legal ground there. And that evidence is much more apparent than trying to prove a racial discrimination claim when there's a lot of unconscious bias that's not necessarily stated. When you're talking about an illness that could be apparent, there's going to be much more direct evidence that's not circumstantial, because you've heard the employee may have heard this comment, the comment directly to the employee, there may be written documentation. So in that circumstance, I do suggest that an employee, if they're dealing with a job termination or some adverse employment action based off of their disclosure that they have COVID, they should seek legal counsel, because it is a factual analysis that has to go into why the decision was.
Wow, thank you. And again, for those who are just tuning in, I'm Alexia Doumbouya, City Director for Philadelphia with Walker's Legacy, and I'm here with Jessica Childress, Esquire, we are talking about Unemployment 101. So I'm just going to take a moment and take a quick question from the audience that we have here. So the question is around Georgia. So Georgia is a right-to-work state. How do states such as Georgia handle unemployment, or are there additional things someone in Georgia would need to think about?
I mean, you do need to think about, if you're unionized, you need to think about your collective bargaining agreement and what this says in the event of a pandemic. You need to think about the no strike laws. So you need to really consider even if you don't have a collective bargaining agreement, if you have an employment agreement, you need to look to see when you're not allowed to work. If there are provisions that there are very few employment agreements that address this, at least in the past. Now, I'm sure there will be more employment agreements that do discuss when you work, assuming that there is a government shutdown, and how to address a pandemic. So these are provisions that we really never thought of in the law. This is just something, it's very much an unforeseen circumstance, but now that we know the likelihood for a pandemic, these provisions are much more likely to be drawn up and put into employment agreements and other workplace policies. So I would take a look at your employment agreements. I would take a look at what your employment policies are. This is definitely a new circumstance. So this is an evolving area of law. So the courts are going to weigh in. And I'm sure in Georgia, where businesses are slowly back up, the courts will slowly weigh back in on how occupational safety and hazard laws apply, the OSHA Act, how that's going to affect the workplace, whether the employer does have a duty to close down when they do know that there's a pandemic outbreak in the workplace, or an actual outbreak in the workplace.
That's awesome. Thank you so much for that. So for those who are listening in, even in your respective states, what Jessica is encouraging us to do is make sure we're familiar with the agreements that we have set in place. In addition to that, seeking counsel from an attorney, specifically in employment law, is really important.
In your state.
In your state, right? Definitely in your state, because things do vary, as Jessica shared. So I know later on in our session around the ourselves more financial freedom or being able to navigate this COVID experience, we're going to talk later on with Mr. Isaiah around the area of like Bitcoin and investment. But I was reading an article today through one of the investment platforms that I use called Stash. One of the things that they mentioned in there around here, and I wanted you to kind of share some insight on, is there is a difference now between who can possibly apply for unemployment. So for instance, they talked about freelance workers, part-time workers, and self-employed. So it seems like in the past, these persons who fit within those categories were not eligible for unemployment because they were making some money. So are we understanding this correctly? Now, sometimes these persons may be able to get unemployment?
Right. Under the CARES Act, the CARES Act is extending the eligibility for unemployment. And so states have the option of expanding their eligibility requirements even more. But the CARES Act has mandated that self-employed people, gig workers, freelancers, they are able to apply for unemployment. But again, you are going to have to show that your income was changed because of COVID. So if you're self-employed, based on your net income, not your gross income like other employees, and you can show that you can show your income through your previous W-2s, but this is certainly giving some financial freedom, if you will, to people who typically would not have been eligible for unemployment. This is the CARES Act. And the CARES Act, it's not an act, at least from what we know now, it's not an act that will be effective forever. It ends at the end of the year. And so this is just, so do know that this is a temporary relief measure.
Okay. That's important. Very important.
And one more addition in terms of the money aspect, the CARES Act is extending the time period for which people are eligible for unemployment. So it's not just the 26 weeks, that's the typical state bar to how many weeks that you can receive unemployment benefits. Now the CARES Act extends unemployment for an additional 13 weeks, and you get a benefit of an extra $600 per week extra. In addition to the unemployment benefit that you would receive based on your income, you receive $600 in addition to that until the end of July. So there's just a lot of cushion built into the CARES Act that was not available previously.
Thank you. That's very important to note too. So another thing I should say that we talked a little about, but I think it is worthwhile dialogue, just to clarify the difference between being terminated, being laid off, and furlough. Would you be able to share some insight for us on that?
Definitely. So termination is typically a one-off circumstance. So you can be terminated, I can be terminated, and we can be terminated really for any reason as long as it's not discriminatory. It's a one-off situation, we're gone. A termination, or a layoff rather, really assesses how many people are laid off. And usually there were mass layoffs. So it's not just one person, it's a group of people, and that decision is not made, it can be made on a number of factors. The decision, typically it's a business decision based off of a reduction in business coming in, and it's a number of people across the department. So that's going to be a layoff, or a number of people being terminated at the same time, not just an arbitrary, let's let this person go because of their performance, which is a single person termination. Now, a furlough, you are essentially, I heard it described last week as a standby employee. That was the first time I'd heard it described that way, but that's a great way to describe a furlough. You are on standby. You are not typically being paid during that period. Your hours can be reduced substantially, but typically employers right now are not paying employees on furlough. So in that period, you're still an employee, you're not getting paid, but you can, and you're on this furlough, you're in this state for a limited amount of time, it's temporary, but you can be called back into work at any time. So you're on standby essentially for the employer. In that period, apply for employment compensation based on the new laws that have been passed. Because you're still an employee, you haven't been terminated, but your hours have been reduced. So now the CARES Act and other state laws are allowing you to apply for unemployment due to that reduction in hours based on COVID.
Wow. Okay. So that is very important. So there's some distinctions there as you consider especially for the employers, but even as an employee that may fall under one of these categories, whether you're terminated, laid off, or if you're placed on furlough. And I've oftentimes heard that term furlough used, especially in the world of construction, field of construction, when you see a lot of seasonality to the employment experience or the business experience, a lot of ebbs and flows. So thank you so much for clearing that up. So another question that I have, and then we'll check to see if we have any more questions from the audience that's listening in. And again, for those who are just joining us, I'm Alexia Doumbouya, City Director from Philadelphia with Walker's Legacy, and I'm here with Jessica Childress, Esquire, who is an employment attorney. So severance. So sometimes when there's been a separation, especially in I think it's more likely in around layoffs, right? The organization could offer severance. So first question is, can you collect severance and unemployment? Second question is, should you collect severance and unemployment?
That's a great question. And the first, states are going to require you to report all income received. So whether that's, if you're receiving unemployment benefits, you have to report all income received, whether that's a severance payment, vacation payout, whether you're working a part-time job, and you actually should be looking for work while you're on unemployment. But going back to, you can collect the severance payment, but again, you do have to disclose it. And there's a formula to determine how much unemployment you're actually going to receive once you apply. And so your severance payout is going to affect that formula and reduce your benefits for unemployment. So you can collect it. You might receive a nice severance payout. So you should, depending on your circumstances, it might behoove you to collect that payment, but you do have to report it to the unemployment division. In terms of the entitlement to severance, you should take a look, if you are facing a termination, you should take a look at your employment policies to determine whether you're entitled to severance. It's not just in layoff circumstances that you actually can receive severance.
Yeah.
There are, in layoffs, there may be the situation where an employer says, okay, we're going to give you a severance payment in order to ask you to waive all claims against us. That does happen in terminations. There are other legal requirements that employers have to comply with for terminations. On mass terminations, there's something called the WARN Act. That's another topic. We can talk about that later, like Alexia. But with severance, you can ask for severance when you leave your job. You may be entitled to it through an agreement, through a severance policy, even if you're a one-off termination, even if you're the only person who's being laid off. If you think that you were laid off for unlawful reasons, there is a reason to ask for a severance payment. And we can go into some considerations for severance agreements. But you should also, when you are leaving the job, and this is whether you're leaving involuntarily or voluntarily, you should look at that vacation payout to determine, is there a pool of money that I've earned that I haven't received? Because these are some areas that people just, terminations are very emotional sometimes, and sometimes we don't think about these other pots of money that we're entitled to. So you should look to see whether your employer promises to pay out vacation if you're terminated, or their policies may state, no, we don't pay it out if you're terminated. It's ours, use it or lose it. But you should be aware of what your rights are.
Very important. And that's a theme for everyone listening in. I'm sure you would agree, that is being aware. So being aware of what your rights are in this situation, even outside of COVID-19, it's important to always be an engaged and educated consumer, as we call them. And so understanding the agreements that you have in place as it relates to your employment relationship, understanding if there is a separation, depending on what bucket it may fall into, it's important to understand. And then, of course, all of this rolling up to the state level, because it does vary by state. So it's not a one size fit all. So especially if you're newer to a state or moved, even, and Jessica, can you speak to, there's a lot of people who live in one state and work in another, especially with the onset of virtual options for people to engage in work. So we're governing ourselves by the state where our employer is domiciled, right?
Exactly, where your employer is, and
Okay.
that employer is paying their unemployment compensation. That's where, so the state where you actually work, okay,
Right.
so that's where, not where you live. Now it might be actually the same place, but it's typically where you work is the place where you are going to file for unemployment.
Yes, and for us in like the tri-state area, there's Philadelphia, so Pennsylvania, there's New Jersey, and there's Delaware kind of right there. And you have even some people that travel. So keep in mind, it is the state where you work, not the state where you. So I do have a question that we would like to pose that came up as we're rounding the hour. Thank you again so much, Jessica, for your time. But this has been a great conversation. So one question that we have, it says, our employer said that we are temporarily laid off possibly until August, but we are still under our employment agreement. How do we get this agreement severed if we want to sever that relationship?
And again, this is not legal advice. This is educational only. So do consult with your counsel in your state so that they can provide specific advice for your situation. But generally speaking, employment agreements are negotiable. You can negotiate them, but if you decide to defer, if you decide to divert from your employment agreement, you really need to understand and understand what your obligations are, and make sure that it's permissible and that it's actually written, that you've modified the agreement to allow the behavior that you are planning on engaging in. So if you, and this comes up a lot in the non-compete context, so a lot of employment agreements have non-competition, non-solicitation. So those are the two big areas, non-solicitation and you can't compete with your employer. And in these circumstances, you may want to start a business that could be competitive with your employer, or you may just want to start another business. And sometimes there are outside activities clauses in agreements that prohibit you from working for anyone else during the term of your employment agreement, or even after your employment agreement. And that's pretty restrictive from a financial standpoint, because you might need this extra income. So if you decide to do that, you do need to get it in writing and note that it's modifying whatever agreement's currently in place.
That's good. And so again, for those who may not be familiar with those terms, non-compete or non-solicitation, non-competition, otherwise known as non-compete or non-solicitation, what are the two biggest differences between those two?
Sure. So non-compete, you can't compete. You can't be in competition. You can't have a competitive business. You can't work for an employer. Those are the typical provisions in the non-compete clauses of an agreement. And non-competition agreements, they can be a standalone agreement just with lots of different clauses, or they can be ingrained into a larger employment agreement that has a number of other restrictions and obligations that you owe to your employer. A non-solicitation provision, and that again can be a standalone agreement, or it can be a part of a larger confidentiality agreement or part of a larger employment agreement. But a non-solicitation agreement prohibits you from soliciting or asking other people from the current company that you work for to work for you, from taking customers. There's usually a non-solicitation provision regarding customers, so you cannot solicit our clients. Non-solicitation of our vendors is typically a provision. You can't go and get vendors that your current employer uses. So those
What about employees?
Employees, exactly, yeah. Clients, employees, vendors. Those are the two big categories of prohibitions in a non-solicited.
Okay. All right. Perfect. Thank you so much for clarifying that for us. So I have another question from our audience. So if an employee has another job and files unemployment because of them being laid off from their job, why does unemployment place these claims against the business where hours were not reduced?
Well, let's see. Where hours were not reduced from the current because of the person having another job.
Yes.
Because that person, if you're applying for unemployment, you are still losing. You've lost one job, so your hours are reduced. If I'm understanding the question correctly, so your hours are reduced because you've lost one of your jobs, and therefore your income is reduced. So there's a potential claim against the company because of that reduction in hours.
Thank you. And last question we'll take from the audience as we wrap up for this particular session. One of our audience members states, I live in Maryland and work remotely for an employer headquartered in Missouri. And you did kind of allude to this, but just in case they were just joining us, does that mean I should apply for unemployment through the state of Missouri and not Maryland, or should I apply through Maryland?
It should be where they should be paying unemployment compensation into a Maryland fund because they have employees in Maryland. So it should be the case that I'm not sure, who your employer is. And again, you should consult with your independent legal counsel, but it should be that because you're working in Maryland, they're paying into a Maryland fund.
Awesome. Thank you so much. Well, thank you so much to our special guest, Ms. Jessica Childress. This has been an amazing conversation. I've learned a lot. I'm sure everyone that has joined us has learned a lot. Now, please tell people, if you would be so kind, how they can stay in touch with you.
Sure, absolutely. And thank you so much, Alexia, for your great questions. And
thank you.
Happy to discuss these topics because this is an area of law for many of us. So very, very excited to talk about this with you. And I can be reached at info@thechildressfirm.com. That's the best email address for me. You can also reach me. You can also go onto our website at www.thechildressfirm.com. The Childress Firm is on social media, on Instagram and on Facebook at the Childress Firm PLLC.
Awesome. Awesome. Thank you. Thank you. Thank you so much.